Please take your seat. On behalf of the court, I would like to welcome you, representative of the respondent, representative of the applicant. So welcome to this public hearing. During this public hearing, we are going to deliver one judgment. Dr. Eno. The judgment, this judgment will be read by Honorable Justice Gerard Niugeko.
Thank you, Mr. President. The court composed of Sylvain Auré, President, Ben Kioko, Vice President, Gerard Niungeko, Elage Guissé, Rafa Benachou, Angelo Matousé, Marie-Thérèse Mukamulisa, Ntiam Menge, Tulijan Chizumila, Shafika Ben Saula, judges, and Robert Eno, Registrar. In the matter of Nguza Viking and Johnson Nguza, represented by Advocate Donald Deya, Pan-African Lawyers Union Council, versus United Republic of Tanzania, represented by Ms. Sarah Mwaipopo, Acting Deputy Attorney General and Director, Division of Constitutional Affairs and Human Rights, Attorney General's Chambers, Mr. Baraka Luvanda, Director, Legal Unit, Minister for Foreign Affairs, East Africa Regional and International Cooperation, Ms. Kansori Sarakikia, Deputy Director, Human Rights, Principal State Attorney, Attorney General Chambers, Mr. Mark Mulwambo, Principal State Attorney, Attorney General Chambers, Ms. Aida Kisumo, Senior State Attorney, Attorney General Chambers, and Mr. Elisha Suka, Foreign Service Officer, Minister for Foreign Affairs, East Africa Regional International Cooperation, after deliberation, renders the following judgments. The parties, the applicants, Nguza Viking, hereinafter referred to as the first applicant, and Johnson Nguza, hereinafter referred to as the second applicant, alleged that they are citizens of the Democratic Republic of Congo who lived and worked as musicians in Dar es Salaam, Tanzania. The second applicant is the biological son of the first applicant. The respondent state, the United Republic of Tanzania, became a party to the African Charter on Human and People's Rights on 21 October 1986, and also became a party to the protocol to the African Charter on Human and People's Rights on the establishment of an African Court on Human and People's Rights on 10 February 2006. Furthermore, the respondent state deposited the declaration prescribed under Article 34.6 of the protocol on 29 March 2010. the respondent state became a party to the International Covenant on Civil and Political Rights on 11 June 1976. Subject of the application, facts of the matter. The applicants alleged that they were arrested by police officers on 12 October 2003 and taken to Magomeni police station in the United Republic of Tanzania. The applicants Nguza Mbangu and Francis Nguza, who are also the first applicant's sons, and another person, were arraigned before the Resident Magistrate Court of Kisutu, Dar es Salaam on 16 October 2003 on a 10-count charge of rape and on 11-count charge of unnatural offense in criminal case number 555 of 2003. Nguza Viking was the first accused, Johnston Nguza was the second accused, Nguza Mbangu was the third accused, Francis Nguza was the fourth accused, and the teacher was the fifth accused in that case. They pleaded not guilty to the charges. The 10 alleged victims were children aged between 6 and 10 years old, all school pupils in the same class at Mashuja Primary School, Sinza in Kinondoni district. It was alleged that the 10 victims were gang raped and sodomized in turn by 5 adults, including the applicants. On 25 June 2004, save for the 5th accused, the applicants and the 3rd and 4th accused were found guilty of all charges against them and sentenced to life imprisonment and to pay a fine of Tanzanian shillings 2 million to each of the victims. The applicants and the 3rd or 4th accused then filed an appeal before the High Court of Tanzania in criminal case number 84 of 2004. In its judgment of 27 January 2005, the High Court held that the evidence adduced fits the definition of gang rape and substituted the offense of unnatural offense with that of gang rape and dismissed the appeal. The applicants and the 3rd and 4th accused filed an appeal before the Court of Appeal of Tanzania in criminal appeal number 56 of 2005. The Court of Appeal's judgment, delivered on 11 February 2010, quashed the conviction and sentence of the 3rd and 4th accused and convinced the first applicant of 2 counts of rape and both applicants of 2 counts of gang rape and acquitted them of the rest of the charges. The Court of Appeal substituted their life sentences with sentences of 30 years imprisonment. On 9 April 2010, the applicant filed a notice of motion for review of the decision of the Court of Appeal. This application for review was dismissed on 13 November 2015. Alleged violations. The applicants alleged that 1, they were not promptly informed of the charges brought against them. They were held incommunicado for 4 days, deprived of the opportunity to contact a counsel or anyone else. They were maltreated by police officers who insulted them, and it was only after they have spent some time in custody that police officer informed them of the rape charges. Second, the trial was not fair for various reasons. First, the court repeatedly dismissed their request to adduce evidence. The results of their blood and urine tests were not presented in evidence before the trial court, even though the alleged victims claimed to have been infected by HIV, AIDS, and gonorrhea, and the first applicant's prayer to the court for a test to be conducted to establish his impotence was rejected. Third, the court relied on the alleged victim's statements as evidence, whereas the said statements were memory recollections of the room where the rape allegedly took place, and the court did not take into account the fact that the children and their parents had visited the house of the accused persons before the hearing and had studied the premises several times. Fourth, the charges brought against them were fabricated in vengeance, and that the judgment rendered was not based on credible evidence. Fifth, the right to a fair trial was also flouted. Number 6, the respondent state violated or established human rights and international law principles. Number 7, their trial was inequitable and marred by procedural irregularities attributable to the national courts and other state agencies and institutions. And number 8, the trial was unfair at all levels and that they were harassed and their defense was not given due consideration, or resulting in the violation of Articles 1, 2, 3, 5, 7, 1b, 13, and 18, 1 of the Charter. Prayers of the parties. In the reply to the respondent state response, the applicants reiterate their prayers seeking for the following orders from the court. A declaration that the respondent state has violated the applicant's right under Articles 2, 3, 5, 7, 1b, 13, and 18, 1 of the African Charter, to facilitate the production of the following witnesses under this Honorable Court's Rules 45, 1 and 2, parents of children of tender age, teacher of school children of tender age, pediatric expert, an order compelling the respondent state to release the applicant from custody, and an order for reparations, and any other orders or remedies that this Honorable Court may deem fit. End of quotation. In the response, with regard to the court's jurisdiction and admissibility of the application, the respondent state praised the court to rule as follows. 1, that the application has not evoked the jurisdiction of the Honorable Court. 2nd, that the application has not met the admissibility requirements provided under Rule 40, Subrule 5 of the Rules of Court. Number 3, that the application has not met the admissibility requirements provided under Rule 40, Subrule 6 of the Rules of Court. Number 4, that the application be declared inadmissible and duly dismissed. With regard to the merits of the application, the respondent states prays that the court grants the following orders. 1, that the court rejects the applicant's request to facilitate the production of witnesses. 2nd, that the redress sought in the application is rejected. The respondent states also 6 orders that it has not violated Articles 1, 2, 3, 5, 7, 1b, 13, and 18, 1 of the Charter. The respondent states further 6 orders that the applicant continue to serve their sentences accordingly, that the applicants be denied reparations, and that this application be dismissed in its entirety for lack of merit. Applicants' request for calling of witnesses by this court. The applicants requested that the court facilitates the production of parents and teachers of children of tender age years and a pediatric expert as witnesses. The respondent state maintains that this request should be rejected. In view of the fact that the court considered that the written pleadings were sufficient to consider the matter, it didn't deem it necessary to grant the applicant's request. On jurisdiction. Objection on material jurisdiction. The court reiterates its position as affirmed in Ernest Mitwigi versus Republic of Malawi that it is not an appeal court with respect to decisions rendered by national courts. However, as it underscored in its judgment of 20 November 2015 in Alex Thomas versus United Republic of Tanzania, and confirmed in its judgment of 3rd June 2016 in Mohamed Abubakari versus United Republic of Tanzania, this situation doesn't preclude it from examining whether the procedure before national courts are in accordance with international standards set out in the Charter or other applicable human rights instruments to which the respondent state is a party. In the instant case, this court has jurisdiction to examine whether the domestic court's proceedings relating to the applicant's criminal charges that form the basis of their application before this court were conducted in accordance with the international standards set out in the African Charter and the Covenant. Consequently, the courts reject the respondent state's objection that the court is acting in the instant matter as a court of first instance and as an appellate court, and finds that it has material jurisdiction to hear the matter. Furthermore, regarding the allegation that the application calls for the court to sit as a court of first instance, the court notes that since the application alleged violation of provisions of some of the international human instruments to which the respondent state is a party, it has material jurisdiction. This is in accordance with Article 3(1) of the protocol, which provides that the jurisdiction of the court shall extend to all cases and disputes submitted to it concerning the interpretation and application of the Charter, this protocol, and any other relevant human rights instrument ratified by the state concerned. Consequently, the court rejects the respondent state's objection that the court is acting in an instant matter as a court of first instance and as an appellate court, and finds that it has material jurisdiction to hear the matter. Other aspects of jurisdiction: the court notes that its personal, temporal, and territorial jurisdiction has not been contested by the respondent state, and nothing in the pleadings indicate that the court doesn't have jurisdiction. From the foregoing, the courts find that it has jurisdiction to hear the instant case. Admissibility of the application. Conditions of admissibility in contention between the parties. The court notes that the applicants filed an appeal and had access to the highest court. This has to do with the objection based on the alleged failure to exhaust local remedies. The court notes that the applicants filed an appeal and had access to the highest court of the respondent state, namely the Court of Appeal, to adjudicate on the various allegations, especially those relating to violations of the right to a fair trial. Concerning the filing of a constitutional petition regarding the violation of the applicant's rights, the court has already stated that this remedy in the Tanzanian judicial system is an extraordinary remedy that the applicants are not required to exhaust prior to seizing this court. With regard to the issues that the applicant didn't raise during domestic procedure but choose to bring before the court for the first time, the court, in accordance with the judgment rendered in Alex Thomas versus Tanzania, affirms that these allegations happened in the course of the domestic judicial proceedings that led to the applicant's conviction and sentence to 30 years imprisonment. They all form part of the bundle of rights and guarantees in relation to the right to a fair trial that were related to or were the basis of their appeals. The domestic judicial authorities thus had ample opportunity to address these allegations, even without the applicants having raised them explicitly. It would therefore be unreasonable to require the applicants to file a new application before the domestic court to seek redress for these claims. Accordingly, the court finds that the applicant exhausted local remedies as envisaged under Article 56(5) of the Charter and Rule 40, Subrule 5, the rules. The court therefore overrules this preliminary objection to the admissibility of the application. Objection based on the ground that the application was not filed within a reasonable time. In determining whether the application was filed within reasonable time, the court is of the view that although the process of exhaustion of ordinary remedies stops with the appeal at the Court of Appeal, whose decision was rendered on 11 February 2010, the applicant should not be penalized for choosing to pursue a review of this decision. The applicant's application for review having been dismissed by the Court of Appeal on 13 November 2013, the assessment of reasonableness will be based on the time between this date and 6 March 2015 when they filed their application. The court notes that the applicants filed the application 1 year, 3 months, and 21 days after the Court of Appeal dismissed their application for review. In the matter of beneficiaries of late Norbert Zongo and others versus Burkina Faso, the court established the principle that the reasonableness of a time of seizure will depend on the particular circumstances of each case and should be determined on a case-by-case basis. Considering the applicant's situation, that they are lay, indigent, and incarcerated persons without counsel or legal aid, and as the records show, the time expended in providing them access to the court records, they attempt to use extraordinary remedies through the application for review of the Court of Appeal's decision. The court finds that this constitutes sufficient justification as to why the applicants filed the application 1 year, 3 months, and 21 days after the Court of Appeal decisions on the request for review. For these reasons, the court finds that the application has been filed within a reasonable time as envisaged under Article 56.6 of the Charter and Rule 40, Subrule 6 of the rules. The court therefore overrules this preliminary objection on admissibility. Conditions of admissibility that are not in contention between the parties. The other condition regarding the admissibility of the application are not in contention. For each part, the courts also note that nothing on the record which the parties have submitted suggests that these conditions have not been met in the instant case. The court therefore holds that the requirements under those provisions are fulfilled. In the light of the foregoing, the court finds that the instant application fulfills all admissibility requirements in terms of Article 56 of the Charter and Rule 40 of the rules, and accordingly declares the same admissible. On merits, alleged violation of the rights to the respect of the dignity and integrity of the person under Article 5 of the Charter. Article 5 of the Charter provides as follows: every individual shall have the right to the respect of the dignity inherent in a human being and to the recognition of his legal status. All forms of exploitation and degradation of man, particularly slavery, slave trade, torture, cruel, inhuman, and degrading punishment and treatment shall be prohibited. In the circumstances of this case, before the court determines whether the respondent's conduct is a violation of Article 5 of the Charter, as alleged by the applicants, it must first establish who should discharge the burden of proof in this regard. In its previous judgment in the matter of Kennedy Owino Onyachi and another versus United Republic of Tanzania, the court has held as follows: it is a fundamental rule of law that anyone who alleges fact shall provide evidence to prove it. However, when it comes to violation of human rights, this rule cannot be rigidly applied. By their nature, some human rights violations relating to cases incommunicado detention are shrouded with secrecy and are usually committed outside the shadow of law and public sight. The victims of human rights may thus be practically unable to prove their allegations, as the means to verify the allegations are likely to be controlled by the state. In the same above-mentioned case, the court, relying on the jurisprudence of the International Court of Justice, also held that in such circumstances, neither party is alone in bearing the burden of proof, and the determination of the burden of proof depends on the type of facts which it is necessary to establish for the purpose of the decision of the case. It is therefore to this court to evaluate all the circumstances of the case with a view to establishing the facts. In the instant case, the applicants simply assert that they were ill-treated and held in a police cell incommunicado for 4 days. In addition, they state that the first applicant was held in a cell without unsanitary conditions. The applicants have not submitted any prima facie evidence to support their allegations, which could enable the court to shift the burden of proof to the respondent state. In view of the foregoing, the court finds that these allegations lack merit, and the court therefore dismisses them. Alleged violation of the right to a fair trial under Article 7.1 of the Charter. Number 1, allegations that the applicants were not promptly informed of the charges against them, and they were denied the right to call a counsel. The court notes that, strictly speaking, the respondent state has not challenged the veracity of the applicant's allegation in this regard. The record before this court shows that the applicants were informed of the charges against them on 16 October 2003 when they were taken before the Residence Magistrates Court of Kisutu, that is 4 days after they were arrested. In the view of this court, in the specific circumstances of this case, where there were allegations of the rape of children of tender age and the possible need for further investigations, the applicants were informed promptly of the charges against them, and that therefore there was no violation of Article 7.1c of the Charter in this regard. With respect to the applicant's denial of the right to call a counsel, the judgment of the Court of Appeal shows that the applicants were represented by Advocate Mabere Marando during their appeal at the Court of Appeal, and its ruling on the application for review shows that this same counsel represents them for those proceedings. There is no record of proceedings at the Residence Magistrate Court to enable the court to verify whether the applicants had access to counsel when the charges were read to them and in the course of the trial. In these circumstances, the court finds that the allegation has therefore not been proven. From the foregoing, the court concludes that the allegations under consideration are dismissed. Number 2, allegation that the identification of the applicants was not done properly. The issue that this court needs to determine is whether the manner in which the applicants were identified is in accordance with Article 7.1c of the Charter. The court is of the view that the decision on evidence to be adduced regarding the form of identification of accused persons is to be left to national courts, since they determine the probative value of such evidence and they enjoy a wide discretion in this regard. This court generally would therefore defer to the national court's determination in this regard, so long as doing so will not result in a miscarriage of justice. In the instant case, this court notes from the record that in the course of the domestic proceedings, the magistrate's court considered the testimony of witnesses regarding the identification of the applicants, and being satisfied on this, proceeded with the trial. The court finds that, on the whole, there is nothing on the record to indicate that this specific aspect of proceedings occasioned a miscarriage of justice. The court consequently holds that there is no violation of Article 7.1c of the Charter. Number 3, allegation that the applicants were not given copies of prosecution witness statements and the material witnesses were not called for cross-examination. The court notes that the respondent state has not challenged the allegation that the applicants were not provided with the witness statements and that the 4 witnesses above were not called and were therefore not examined by the applicants. The court recalls that in accordance with Article 7.1c of the Charter, everyone has a right to the defense, and that according to Article 14.3b of the Covenant, in the determination of any criminal charge against him, everyone shall be entitled to have adequate time and facilities for the preparation of his defense and to communicate with counsel of his own choosing. The court also notes that Article 14.3e of the Covenant provides that in the determination of any criminal charge against him, everyone shall be entitled to examine or have examined the witnesses against him and to obtain the attendance and examination of witnesses on his behalf under the same condition as witnesses against him. The court is of the view that in the instant case, the applicant should have been provided copies of the prosecution witness statements in order to facilitate them to prepare their defense. By this not having been done, the applicants were placed at a disadvantage vis-à-vis the prosecution, contrary to the principle of equality of arms. Similarly, by not calling the 4 aforementioned persons to testify, the applicants were denied the opportunity to cross-examine them, and this also placed them at a disadvantage. Consequently, the court holds that the applicant's denial of access to the prosecution witness statements and denial of an opportunity for the applicant to cross-examine persons who would have been material witnesses was a violation of Article 7.1c of the Charter by the respondent state. Number 4, allegation that the applicant's alibi defense was unduly rejected. In its previous judgment, in the matter of Mohamed Abubakari versus Tanzania, this court held that where an alibi is established with certitude, it can be decisive on the determination of the guilt of the accused. In the instant case, however, the records of the domestic judicial proceedings show that the applicant's evidence of an alibi was considered and rejected by the respondent state trial and appellate courts. The record of proceeding reveals that the High Court and the Court of Appeal specifically addressed the alibi defense and rejected it after weighing it against the testimony of the witnesses, finding that the witnesses' testimony was sufficiently reliable to set aside the applicant's alibi defense. The court finds that, on the whole, there is nothing on the record to indicate that the setting aside of the applicant's alibi defense occasioned a miscarriage of justice. Consequently, the court holds that the respondent state has not violated the applicant's right to defense as enshrined in Article 7.1c of the Charter and thus dismisses the allegation. Number 5, allegation that the applicant's urine and blood tests were not tendered and the first applicant's request for an impotence test was unduly rejected. The applicants allege here the violation of Article 2 and 3 of the Charter, which protects the right not to be discriminated against and equality before and equal protection of the law, respectively. The court will, however, consider this allegation under Article 71C of the Charter as it actually relates to the right to defense. The court notes that all material evidence impacting on an accused person's defense should be considered and reasons for its exclusion provided. This is because their liberty is at stake. The court notes that the applicant's blood and urine test results, which in the applicant's view would have bolstered their defense, were not tendered in evidence at the trial court, therefore denying them the opportunity to tender material evidence in their defense. The courts also, however, note that in the circumstances of the case, neither the High Court nor the Court of Appeal based their guilty verdicts on the results of the blood and urine tests. Therefore, the applicant's right to defense was not violated in this respect. On the other hand, as regards the impotence test, the court is of the view that once the first applicant raised the issue, the respondent state should have facilitated the test to be done, since the outcome thereof would determine whether the first applicant could have committed the crime. Consequently, the court holds that to the extent the trial court rejected the first applicant's prayer to be tested on his impotence, the respondent state has violated his right provided in Article 71C of the Charter. Number 6, allegation that the trial judge was biased and that some of the applicant's submissions and evidence were not duly considered and taken into account. The court recalls again that at the trial court, there were 5 accused persons, including the applicants. The record before this court shows that the Court of Appeal examined each count and in the end acquitted the 3rd and 4th accused, reducing the number of counts that were proven against the applicants to 4 as against the original 21. In a previous case, this court has stated as follows: general statements to the effect that this right has been violated are not enough. More substantiation is required. The court notes, however, that in the instant case, the applicants have not provided sufficient evidence as to the alleged bias and to the possible implications of the alleged violation of the trial court's judgment. Accordingly, the court finds that the alleged violation has not been proved and therefore dismisses it. Now we come to allegations of violation of the right to participate in the governments of one's country under Article 13 of the Charter and the right to protection of the family under Article 18.1 of the Charter. Article 13 of the Charter provides that every citizen shall have the right to participate freely in the government of his country, either directly or through freely chosen representatives in accordance with the provision of the law. Every citizen shall have the right of equal access to the public service of his country. Every individual shall have the right of access to public property and services in the strict equality of all persons before the law. Article 18 of the Charter provides as follows: the family shall be the natural unit and basis of society. It shall be protected by the state, which shall take care of its physical health and moral. On those points, the court notes that the applicants limited themselves to stating that their rights under Article 13 and 18.1 have been violated by the respondent state. They have not specified how and in what circumstances the alleged violations occurred. As indicated above, this court has stated in its previous judgments that general statements to the effect that the right has been violated are not enough and that more substantiation is required. In view of the aforesaid, the courts found that the allegation of violation of Article 13 and 18.1 of the Charter have not been established and accordingly dismisses those allegations. Allegation that the respondent has violated Article 1 of the Charter. The court notes that in instances where an allegation of violation of Article 1 of the Charter has been raised, the court has held that when the courts find that any of the rights, duties, and freedoms set out in the Charter are curtailed, violated, or not being achieved, this necessarily means that the obligation set out under Article 1 of the Charter has not been complied with and has been violated. In the instant case, the court has held that the respondent state has violated Article 7.1c of the Charter with respect to some of the applicant's allegations. On the basis of the foregoing observations, the court thus finds in conclusion that violation of the said rights entails violation of Article 1 of the Charter. Remedies sought. Article 27.1 of the Protocol provides that if the court finds that there has been a violation of human or people's rights, it shall make appropriate orders to remedy the violation, including the payment of fair compensation or reparation. In this respect, Rule 63 of the rules provides that the court shall rule on the request for reparation submitted in accordance with Rule 34, Subrule 5 of these rules, by the same decision establishing the violation of a human and people's rights, or if the circumstances so require, by a separate decision. With respect to the applicant's request to be released from prison, the court notes that this prayer is moot, considering that according to both parties, the applicants have been released by way of a presidential pardon. Concerning the other forms of reparation, the court notes that none of the parties made detailed submissions. It will therefore make a ruling on this question in another judgment after having heard the parties. Costs. The applicants pray the court to order the respondent state to pay costs. The respondent's state has not made any prayer as to costs. The court notes that in this regard, that Rule 30 of the rules provides that unless otherwise decided by the court, each party shall bear its own cost. Having considered the circumstances of this matter, the court decides to deal with the question of cost when considering the other forms of reparation. For these reasons, the court unanimously on jurisdiction, 1, dismisses the objection to the jurisdiction of the court. 2, declares that it has jurisdiction. On admissibility, 3, dismisses the objections on admissibility of the application. 4, declares the application admissible. On the merits, 5, finds that the respondent state has not violated Article 5 of the Charter. 6, finds that the respondent state has not violated Article 7.1c of the Charter as regards the failure to promptly inform the applicants of the charges against them and denying them an opportunity to call their counsel, the manner of the applicant's identification, the rejection of the applicant's alibi defense, the failure to admit the reports of the applicant's urine and blood test as evidence, and the alleged partiality of national courts. 7, finds that the respondent has violated Article 7.1c of the Charter as regards the failure to provide the applicants copies of witness statements and to call material witnesses, the failure to facilitate the first applicant to conduct a test as to his impotence, and consequently finds that the respondent state has violated Article 1 of the Charter. 8, finds that the allegation of violation of Article 13 and 18.1 of the Charter have not been established. 9, holds that the applicant's prayer to be released from prison has become moot. 10, orders the respondent state to take all necessary measures to restore the applicant's rights. 11, defers its ruling on the applicant's prayer on the other forms of reparation, as well as its ruling on costs. And 12, allows the applicants, in accordance with Rule 63 of the rules, to file their written submission on the other forms of reparation within 30 days from the date of notification of these judgments, and the respondent state to file its response within 30 days from the date of receipt of the applicant's written submissions. Done at Arusha, this 23rd day of March 2018, in the English and French languages, the English text being authoritative.
This is the decision of the court.